Thank you, Madam Speaker. Madam Speaker, I beg to move that a bill entitled An Act to Amend the Summary Courts Act, Chapter 420, to remove the requirement for consent for joinder of complaints in summary judicial matters be now read a second time. Madam Speaker, the bill before us is an extremely short expression of amendment to law. The bill proposes that we amend the Summary Courts Act, and that we do so, Madam Speaker, with the specific intention of amending Section 64(2) of the Summary Courts Act to effectively remove two aspects of the Summary Courts provision. We seek, Madam Speaker, in relation to these amendments, to remove the express consideration that a defendant needs to be informed and that a defendant must consent where more than two people are before the magistrate's court charged with summary offences. Allow me, Madam Speaker, to explain the purpose of the legislation in the context of what the law is. Now, Madam Speaker, the Summary Courts Act, Chapter 420, is an Act of Parliament number 9 of 1918. We are well over 100 years since the birth of this legislation. In particular, Madam Speaker, the legislation, the Summary Courts Act, summary offences, for those who are tuning in, Madam Speaker, are to be distinguished from indictable offences. Summary offences are treated with in the magistrate's court exclusively, in the general sense of what prevailed from 1918 come forward. Summary offences can now, with amendments being brought to life, be treated in the High Court if when we get to the abolition of preliminary inquiries. We have also had certain amendments which allow the High Court to treat with other summary offences, particularly in the Family and Children Division and in general in the merger of jurisdictions between the High Court and the Magistrates' Court. But generally speaking, the summary offences are treated with by magistrates. In the judicial system, Madam Speaker, it is a matter of public record produced every year in the annual statistical reports coming from the judiciary that the magistracy is the first port of call for the vast majority of cases in the criminal justice system. In particular, the average is somewhere close to 125,000 to 146,000 cases per year being treated within the magistrate's court. Madam Speaker, by way of statistical information grounding the recommendations for this bill, permit me to put on record the following information. At the magistracy, for the year 2020 to 2021, there were 13,925 summary offences brought. There were also 1,397 private complaints brought. Because, Madam Speaker, most people may not be aware, but private individuals can bring criminal offences, criminal matters, criminal charges before our courts. Now, in the period 2019 to 2020, the number was 10,862. There were 4,520 private matters. In the period 18 to 19, there were 14,360 matters, and there were 7,923 private matters. In the period 2017 to 2018, there were 17,012 summary matters, and there were 8,242 private matters. In 2016 to 2017, there were 14,927 matters, versus 8,808 private matters. Now, Madam Speaker, that puts us with a 10-year average of approximately 14,693 cases. 14,693. If we extrapolate and we drill a little bit further down into what statistics look like for multiple offenses, nearly 20% of matters are for multiple offenses. And if we drill even further, anywhere between 6 to 10% on average may involve multiple persons. So, Madam Speaker, whilst we are heavily engaged in making sure that the criminal justice system focuses upon matters in a more speedy fashion, whilst the Chief Justice has led criminal justice management and reform, including up to today in publications via the Law Association, indicating judicial docketing right up to the Court of Appeal, Madam Speaker, whilst we improve plant and machinery, people and processes alongside law, it is important for us to now drill even further down into how we can manage more efficiently the thousands of matters that appear in the magistrate's court where multiple persons stand before the court on multiple matters. So let's look to the Summary Courts Act itself. Section 64 of the Summary Courts Act says it is, in the marginal note is cross complaints, and 64.2 deals with joinder of complaints. So the issue that we're treating with is joinder of complaints. 64.2, as the law currently stands, says where two or more complaints are made by one or more parties against another party or other parties, and such complaints refer to the same matter, such complaints may, if the court thinks fit, be heard and determined at one and the same time if each defendant is informed of his right to have such complaints taken separately and consents to their being taken together. That's what the current law says. The bill before us proposes, Madam Speaker, that we repeal 64.2 and we now provide for a new 64.2. It says where two or more complaints are made by one or more parties against another party or other parties in the same matter, and the complaints in that matter are founded on the same facts, the complaints may, if the court thinks fit, be heard and determined together unless the court determines that separate proceedings are required in the interest of justice. So we are moving away from the restriction in our statute which says that you must inform the defendant and that the defendant must consent. And we are doing that, Madam Speaker, because most people are not aware that magistrates are creatures of statute, and they are also perhaps not aware that the statute itself, the Summary Courts Act, is what magistrates must operate with. So we have this particular arrangement where consent is required. You're required to be informed and you're required to consent. And if consent is not provided, you are bound to separate the trials. Now, Madam Speaker, what that has resulted in is significant delay in the determination of matters where, Madam Speaker, number one, other jurisdictions in the Commonwealth, starting with the United Kingdom and moving through several Caribbean territories, do not have this form of statutory restriction. Number two, where the interest of justice is managed as the overriding objective in the common law. Further, Madam Speaker, where we are treating with the fact that with aggressive case management at present being conducted, with backlog committee sitting as they are right now, there is intended to be an aggressive management of trials in the magistracy as we proceed in the months and years ahead. In all of the circumstances, therefore, Madam Speaker, the government recommends, coming out of our consultations in the Criminal Justice Sector Committee, where the Law Association, the Public Defenders Division, the Legal Aid Advice and Authority, the DPP's division, and the judiciary, headed by no less a person than the Honourable Chief Justice himself, have all agreed that this matter should be treated with in the fashion that the government proposes today. I should say, Madam Speaker, that the particular amendment springs from a direct recommendation coming from Madam Justice Alice York Suhan. And I say that, Madam Speaker, because I'm now going to go to two very important points in relation to the law. In seeking the amendment that we do right now, albeit in the summary jurisdiction, I must point out that the indictable end of the criminal justice sector already has what I can call the exact approach. And if we look to the Criminal Procedure Act, Chapter 1202, Section 13, if we look to the Criminal Procedure Act first schedule on indictable rules at Rule 3, if we look to the case law arising on the joinder of parties for indictable matters, and particularly, Madam Speaker, I note the case of R versus Asim, 1966, at 2 All England Reports at 881. If I look to the case of Nandlal, well known to many of us here, versus the state, 1995 at 49 West Indian Law Reports at 412, the dicta, the learning in the indictable arena, which we seek to match up by the amendments today in the summary arena, is that it is acceptable to charge all of accused persons together in one indictment, even if they were not implicated in one count. So says Nandlal. It is acceptable in the joinder of charges that there is no issue of consent being required by the defendant. And that's in the indictable arena. So if the law stands in the indictable, i.e. the more serious arena, indictable offenses being determined to be more serious than summary offenses as a theory of law, if there is no requirement for the defendant's consent and it is left to the interest of justice, well within the Constitution of the Republic of Trinidad and Tobago, in a fair trial requirement with due process requirement, then, Madam Speaker, it is axiomatic that the summary arena, the amendments we seek to Section 64.2, ought to match up with our indictable approach, Madam Speaker. And that, Madam Speaker, also takes into account the entire argument on abuse of process. And in the indictable arena, if I borrow from the dicta in Bola Nandlal versus the state, Madam Speaker, it is important to bear in mind that the abuse of process argument in separating trials into multiple trials, or multiple trials one after the other, one can find an equation of an abuse of process if in certain circumstances joinders are not permitted as a matter of interest of justice, Madam Speaker. That is where all the relevant offenses, all the relevant charges are put forward in the best administrative use of the judiciary's time, the defendant's fair opportunity, the prosecution's fair opportunity. Now, Madam Speaker, this is particularly so because we have merged jurisdictions between the High Court and the magistracy. We intend to allow, in the abolition of preliminary inquiries, the fact that a judge sitting in an indictable matter may also hear summary matters at the same time. We intend, in the backlog management, in the categorization of case type and methodology, to allow for a cleanup of the lists that is aggressively proceeding. And therefore, Madam Speaker, we propose to work the amendments wherever we can catch them by allowing for better interest of justice. In the year 2020 to 2021, January 2020 to December 2021, Madam Speaker, this would have amounted to no less than anywhere from 403 matters involving multiple accused, and for multiple offenses, some 1,428 matters. Now, when you take that across the platform of having 43 magistrates, you understand that to deal with nearly 1,500 matters, to deal with 500 multiple accused matters, it is imperative that judicial time is spent in the most efficient way possible. So, Madam Speaker, from a data perspective, it is critical for us to treat with this. Now, I had mentioned the Honourable Madam Justice of Appeal Alice York Suhon, really and truly because it is the decision that that Honourable Justice of Appeal sat in that has quite a significant amount of expression for us that I think is important to have on the parliamentary record. And of course, Madam Speaker, I'm referring to the case where Justice of Appeal York Suhon sat. It is the Magisterial Appeal number 930 of 2008. It is the case of Fazal Dindial and Rajesh Deosaran, Police Constable number 12861 as the respondent. The panel at the Court of Appeal was Madam Justice of Appeal Alice York Suhon, sitting with Mr. Justice of Appeal Prakash Musai, and it was delivered on the 15th of December 2017. In this particular matter, Madam Speaker, may I ask what time is full time?
Full time ends at 3:11.
At 3:11. Thank you. In this particular matter, there is a very useful analysis of Section 64.2 of the Summary Courts Act. And when we look to the fact that the court was considering as one of the grounds of appeal whether there ought to be an appeal because the argument raised by the appellant was that he had not been informed of the right to have the complaint heard against him separately from a co-accused, and then seeking his personal consent to do so. In considering that ground, Madam Justice of Appeal York Suhon, Mr. Justice of Appeal Prakash Musai, who delivered the judgment, was very clear in pointing out the history of this particular law. And it's quite interesting to note that the judgment reflected upon the fact that not only was this particular law, the summary convictions, born in the Summary Convictions Offences Procedure Ordinance, that is number 9 of 1918, and then brought in as Section 61 of an ordinance which found itself into the law that we're today treating with, Madam Speaker, but that Section 64.2 came about in 1936 by way of an amendment and Act number 22 of 1936. And when we look to the considerations of the Honourable Justice, Mr. Justice of Appeal Prakash Musai, he reflected very positively upon the leading case set out in the English law. And in the English law, and Madam Speaker, it can be found in the learning that we all go to in Blackstones, if you were to look for the English law, the case of Clayton versus the Chief Constable of Norfolk. That particular case, 1971, Appeal Cases 29, is positively reflected upon by our own Court of Appeal in this magisterial appeal. And in it, they note specifically that the statute does confer a discretion on the magistrate as to joinder, but that the circumstances are as set out. You must inform the defendant, and there must be consent of the defendant. But in holding that the particular case was not one which ought to be set aside on appeal, it is the reflection upon the propriety of Clayton, that is the English case. It is the reflection upon the use of statutory interpretation that finds itself in that judgment in saying that, and I want to quote, Madam Speaker, from paragraph 23 of the judgment as to part of it, if you'd permit me, where the judge sets out that it is also inconceivable that a defendant in this day and age would not opt, say, for 6 separate trials, with the attendant cost and inconvenience, when one would suffice. It could hardly have been the intention of Parliament that, given the procedural nature of Section 64.2, open brackets, to prevent a multiplicity of proceedings, close brackets, non-compliance would result in the total invalidity of proceedings. A breach of this nature could not properly be categorized as a breach of a fundamental rule of procedure, and in any event to hold that a breach of the most trivial nature would invalidate the entire proceedings would be disproportionate and extraordinary. But because the learned judges went on to note at paragraph 27 as follows, it is imperative, notwithstanding the Court of Appeal's fulminations, that we proceed to amend the law so that there is not future argument upon the interpretation to be provided to section 64.2. And Madam Speaker, permit me to quote from paragraph 27 of the same judgment. Before concluding this issue and proceeding with my analysis of the other arguments raised, I find myself in the unenviable position of having to remind judicial officers of the importance of complying with statutory requirements. Precious judicial time is spent hearing and adjudicating over grounds of appeal based upon a magistrate's failure to comply with statutory requirements or having to navigate and make sense of ambiguous approaches to compliance. It is somewhat disquieting to observe that this apparent trend centers around adherence to the least complex and decidedly straightforward of statutory duties. Regardless of any apparent simplicity or lack thereof, as was reiterated most recently in the Privy Council case of Wright versus the Queen, statutory duties are not mere formalities, and a failure to comply can, in appropriate circumstances, amount to a material irregularity. Specific to section 64.2, it is but the work of simple comment and inquiry to ensure that a defendant is made aware of his right to a separate hearing and that his consent to proceed without hearing is obtained. It is the responsibility of magistrates to ensure that these requirements are complied with. Now, I've put that on the record because it's important to note in eminent jurisprudence, and in particular I refer to, God rest her soul, Dana S. Sitahal's book, Commonwealth Caribbean Criminal Practice and Procedure, 4th edition, when we look to chapter 5 of her particular work, and we get into the understanding of this issue of joinder in the summary court's context, there are a series of cases that the author refers to where the courts had to spend time as to whether the consent for the joinder offered by counsel was adequate versus the consent to be directly obtained from the defendant, whether it is to be implied by presence of the defendant in court or not. So, Madam Speaker, the sensible thing for us to do is to borrow from our experiences in other jurisdictions, or the experiences in other jurisdictions, particularly if we look to Blackstone's and we look to the recommendations coming with respect to the discretion to try charges separately. Again, the Chief Constable of Norfolk versus Clayton stands as the dicta that is still of prevalence in the English common law approach, and that was in 1983 where Lord Ruskill set out the practice there about the interest of justice. If we look, Madam Speaker, to the Magistrates Court, 1996-27, Chapter 116A of Barbados, and we reflect upon the hearing of two or more complaints at the same time in Section 95. If we look to the Criminal Procedure Code, Chapter 172 of St. Vincent and the Grenadines, and we look to Section 70, Complaint and Charge of that law. If we look to the Criminal Justice Administration Act of Jamaica, and we look, Madam Speaker, to Section 22 of that law, if we look to the laws of Guyana, the Summary Jurisdiction Procedure Act, Chapter 1002, we are clear, Madam Speaker, that there is ample precedent in the Caribbean context, let alone the English common law context, where we ought to leave it to the court in the interest of justice, there being similar expressions in all of the laws that I've just referred to, Madam Speaker. It is essentially the interest of justice that the court ought to consider in deciding whether there ought to be a joinder of charges, a joinder of persons standing before the court. That, Madam Speaker, is the overriding objective. That is the legitimate aim that we stand here today to succeed in passing law, Madam Speaker. Madam Speaker, whilst this is a very short bill, it has dynamic and critical impact to the criminal justice system. It will allow, now that we have multiple techniques, maximum sentence indication, plea bargaining, judge-only trials, if we're going to have it at the indictable and summary being tried together perspective, where we're dealing with multiple accused, Madam Speaker, as we have aggressive backlog management, as we have the opening of multiple courts, the judiciary having already partially occupied the waterfront courts and aggressively moving to open those courts so that the criminal arena is pushed forward, with the birthing and opening of the jury trial courts at Omera, Madam Speaker, with the simplification of divisions, with the attendance of witnesses virtually and attorneys virtually, Madam Speaker, all of these things tell us, let us get the caseload managed. Because it is only with the management of caseload, Madam Speaker, that people are going to see the delivery of justice. Because whilst I as Attorney General and this government can stand and say that we have made epic and important reforms, the people of Trinidad and Tobago need to feel that sense of justice. And justice delayed is justice denied. And whilst I can promise and make assurances that justice has fast quickened, that resources have been put in that have never before been seen in the criminal justice or civil justice arena as it has been implemented now, the people of Trinidad and Tobago want to see so that they can believe, so that there can be faith and confidence in the system. So, Madam Speaker, we most humbly recommend that we leave the decision of joinder to the court's discretion, whether matters should be heard and determined together, unless the court determines that separate proceedings are required in the interest of justice. In all of those circumstances, Madam Speaker, I beg to move.